our Blueprint series. My name is Kelly Young. I'm a legal counsel with the Justice Collaborative. To provide our newcomers with some context, the Justice Collaborative's Blueprint for a Safer and More Just America is a comprehensive framework for national criminal justice reform and outlines concrete steps to address the country's mass incarceration crisis and provides actionable solutions to creating a fairer and more equitable justice system. And the very first principle outlined in the Blueprint is to stop making poverty a crime. And on that topic, today our awesome panelists will discuss how the use of cash bail does just that and what's being done across the country to end this practice. Before I introduce them though, I always want to thank our justice volunteers for the great work that you do, whether that's through research, media amplification, or on one of our various student teams. You've completed research on upcoming prosecutor elections in more than 1,000 counties across the country, pressured Oregon lawmakers into not holding a special session that would roll back important death penalty reform. And since our last webinar, almost 1,700 of you signed onto a petition to show support for sentence review units. You're all amazing, and I'm happy to be in this fight with you. Towards the end of this webinar, you'll hear from Molly Bernstein, our Associate Director for Volunteer Research and Advocacy, about how you can be more involved in our teams and work to end the criminalization of poverty. And now for our panelists. Joining us, we have Summer Lacey, Senior Legal Counsel with the Justice Collaborative, Jocelyn Simonson, Visiting Associate Professor of Law at Harvard Law School, Brittany White, Live Free Texas Manager at Faith in Texas, and Adam H. Johnson, host of the Appeal Podcast and co-host of the Citations Needed podcast. Thank you all for being with us. And as I start the discussion, if you have any questions, please feel free to write them in the comment box along with your name and where you're from, and we will do our best to get to as many of these as possible. So to start us off, Jocelyn will be framing the issue, letting us know what cash bail is and why we should care about it.
Great. Hi. Thank you so much for having me. So we're here to talk about cash bail. First thing I guess to talk about is what cash bail is, and then I'm going to talk a little bit about why we should care about it before passing it on to others to go into a little bit more about the impact of the mechanism of cash bail. So there are, at any one time today, more than 450,000 people are incarcerated in jails pre-trial, meaning they've been charged with a crime, but their case isn't over yet. No one's determined whether they're guilty, no one's pled guilty to anything, and there certainly hasn't been a trial. And for most of those hundreds of thousands of people, they're there because a judge has set bail or bond in some way. And the idea of bail is a very old idea. The idea is, and it sounds logical at first, that there's a certain amount of money that someone can pay, then the fact that the state is holding on to that money will ensure that they come back to court for their next court date, because then they'll get the money back. So bail or bailment was initially a way for someone to not be incarcerated pending trial, with some kind of monetary incentive for them to come back to court. Instead of it being a way to let people go, it's actually become a way to incarcerate people pre-trial in a way that a lot of actors in the system have acknowledged as the purpose of what they're doing. And it's also become connected with a different idea of pre-trial detention or pre-trial incarceration for the purpose of making sure that somebody doesn't commit other crimes, or ensuring that someone doesn't commit other crimes, often referred to as public safety, ensuring public safety. And bail can happen in different forms. Often a judge will say, I'm setting, I'm requiring a $20,000 bond, but you can pay a percentage of that in order to be released. And I should also say, there are a lot of people who are not incarcerated who have had to pay money to be free. So that number of hundreds of thousands of people is only that subset that can't pay that money. So when we talk about punishing poverty, part of what people are talking about is the fact that hundreds of thousands of people are sitting in jail, and technically, according to the law and according to the Constitution, which we'll talk about later, they're not being punished. They're just there because they can't pay that amount to be released to ensure that they'll come back to court. And studies are continually showing that people don't need to have money on the line to come back to court, and that there's not really any correlation with whether people get rearrested. But that's the idea behind cash bail. Why should we care about it? One reason, and I think that's sort of the headline of this webinar, is that it's literally incarcerating people for their poverty, for the fact that they can't pay a certain amount of money. And that's a reason that I think resonates with a lot of people from different political spectrums. It's incarceration for poverty rather than for something somebody did. Another reason we should care about it is that it correlates not just with class, but also with race, given the structural ways that race and class are related in the United States, and given the ways that policing and targeting of certain communities works. So when we're talking about hundreds and thousands of people, we're talking about disproportionately people of color. Another way is that it's a way of incarcerating people pre-trial, full stop. So one reason we might care about money bail is not just that people are there because they're poor. Most people who are prosecuted are poor, but because people are being incarcerated pre-trial without having been convicted of anything. And that might violate our ideas of the presumption of innocence. It also has an effect on the outcome of cases, which we can talk about more. And it has devastating consequences for people. Jail's a violent place. It affects people, their families, and their communities. So those are some sort of previews of ways that we might care about money bail. And I would encourage us as we talk to think not just about punishing poverty, but also the dangers, problems, and why we should care about pretrial detention itself. And I will pass it along now.
Thank you so much, Jocelyn. And so we're going to kind of give some more context about what, cash bail means in real life and what that social context is. And so, Brittany, could you get us started with that conversation?
Absolutely. Good morning, everyone. My name is Brittany White. Honored to be a part of this highly esteemed panel this morning. And I am a formerly incarcerated Black woman. I spent 5 years in prison in the state of Alabama. And I was arrested in a very rural county. And the first thing that I really want to ground us in is what makes bail so egregious is the very simple concept that we already know. You cannot get time back. Time lost is forever gone. So every single day, every single moment that people sit in jail just because they are too poor to be able to bond themselves out, they literally cannot get that time back with their family. They oftentimes lose employment, they lose housing, and the effect to Jocelyn's point about being incarcerated is a violent experience is something that is permeating through every area of their life. So this fight about money bail isn't just about policy, but it's also very much grounded in the everyday experience that it has a long-lasting effect on people's lives. One thing that I have to contend with as a free Black woman is that every day that I lost of those 5 years is gone. And I have to move forward with my life being well with all of the opportunities that are also gone along with that time. So I think as a community, the perspective and what we're remaining grounded in is that we're trying to preserve the talents, the experience, and the genius of people. And if we are not able to give people the time and the freedom to live into the talents that they offer us as a community, it is a personal loss to that person's life. It is the suffering that the family endures and having to fill up the gaps that they're not able to step into while they're incarcerated. And there is a collective impact that we feel as a community in losing the talents and the gifts and the construction that person offers to a community.
Thank you, Brittany. And Summer, can you kind of piggyback on that, talking more about the impact on the family and the community, and then to Jocelyn's point, what the impact of pretrial detention has on the outcome of a person's criminal case?
Yes, of course. Good morning, everyone. And just to initially piggyback on what Brittany was saying, when someone is detained pretrial because they can't afford to pay their bail, that's devastating not just to the person's individual life, but to their family. And it's not just devastating to their family, but it's often debilitating. I worked as a public defender for 7 years before joining the Justice Collaborative. And whenever I talked to a judge about releasing one of my clients, I would give that judge a snapshot of my client's life. And I wouldn't just focus on the ways in which my client was going to be affected by detention, but the ways in which his or her family would be affected, the ways in which their coworkers would be affected, the ways in which their community would be affected. And oftentimes what I found is that judges were even more compelled by the way others were affected by one person's detention, because those other people, those family members, those community members, I mean, they hadn't even been arrested at all, but their lives were negatively shaped by pretrial detention, by a system where someone couldn't pay the money to return to their family. And jumping into the ways that families are affected, first and foremost, financially. If someone is working, then that means that when they are in custody, they cannot work, they lose their job, and their family, importantly, loses that source of income that they rely upon. And if we're talking about parents, single parents, that means that not only does their family lose their income, but who are their children going to be with? Their children have to go live with family members, or they have to go under the care of the county or the state. So that is devastating to the family. Also, the person is not able to participate in just the daily structure, daily life events. They can't pick their children up from school. They can't drop them off. They can't care for older family members. They can't help out in church communities. They can't care for pets. I mean, they might sound like small things, but when you think about what our lives are made of, you think about what Brittany said, the time that you can't get back, that is instrumental, and it really forms our existence. Also, when someone is incarcerated, if that person is the head of the household, if the lease agreement is under their name, if their family lives in some sort of community or public housing, that means their family could lose out on their housing. Incarcerated people can no longer contribute emotionally to their family, and they become disconnected. I saw that as someone was incarcerated or detained pretrial, the longer their case took, the less likely it was for their family to be able to go to court, to see them, go to make visits to a detention center, not because the family didn't care, but because there were so many extra burdens put on the members where they didn't have the time or the money or the space to support the loved one that was going through the criminal legal process. Also, family members often find themselves in difficult situations where they have to look to alternative or even dangerous means to secure extra money. And that's really just focusing on, the people who are incarcerated who have families. There are people who are incarcerated who are disconnected from their families. They might be struggling with houselessness. And when those people are incarcerated, that means that they could lose all of their possessions. They could lose the place where they lay their head each night, places that they, had to work hard for just to get that space because they don't have a home to come back to. And so it means that for them, and really for many others, their life and the life of the people who depend on them is much worse once they get out than when they initially went in. And then moving next to some of the broader communal effects of bail, I think one thing to think about is even when bail is paid, it's very detrimental to communities because mainly the money will come from either impoverished communities or communities of color. In 2017, in Los Angeles County, Black and Latino residents paid an average of $29 million in non-refundable bail bond deposits. So that means that's money that they paid to a bail bond company in order to get their loved one out on bail. And that's money that they didn't get back, $29 million. And so that's money that is funding this multi-million-dollar bail industry that's basically gaining speed and profiting off of the backs of people who are the most marginalized. And bail isn't supposed to work that way. Incarcerating people just because they're poor isn't supposed to be the goal. And charging people money isn't something that's going to definitively ensure that they are going to come back to court every single day. Studies show that when someone is incarcerated pre-trial, they are more likely to be convicted of the charged offense, and they are more likely to commit future crimes. So in the end, it is making us all less safe when people cannot afford to basically pay for their freedom. And lastly, I want to talk about the impact on the person's criminal case. I mean, I've said it, and I believe Jocelyn and Brittany both talked about the fact that when someone is incarcerated pre-trial, they're more likely to be convicted of the charged offense. Studies show that when someone is incarcerated pre-trial, they are 26% more likely to be convicted of a felony, 27% more likely to be convicted of a misdemeanor, but the effects go a lot farther than that. When someone is detained, they do not have a meaningful opportunity to look through the evidence that is against them. They have a harder time working with their attorney to develop strategies of defense. They become disconnected from their family or the people that they turn to for guidance. So these are people who are going through some of the most difficult periods of their life, but they're removed from their support system. It also becomes more difficult for people who are in custody to provide investigative leads to their attorneys. I would meet with clients and they would say, or we would talk about a potential defense and they would say, well, go talk to this person. And they, didn't know that person's full name or didn't have their cell phone, so they couldn't give me their number. And so they're giving me someone else's number who didn't know that person. And so, I was just on a wild goose chase, losing time that I could have been using to help that person. If that person was out, they could have just led me to these sources of information, led me to evidence that would have either been exonerating or mitigating for their case. Also, something that isn't talked about is the fact that a person's life and prospects for disposition, so like sentencing prospects, are shaped by whether or not they're in custody or out of custody. When I had clients who were released, they were able to enter drug treatment programs, mental health treatment programs, continue working at their jobs. They started taking classes. They got extra degrees. They started working more in their community. And when it came time for sentencing, if that's where their case went, I was able to tell the judge all of these things, present certificates, present letters from all the people that were affected by my clients during the time leading up to their sentencing. And my clients who remained in custody, they were able to participate in the limited programs that were at the detention center, but they weren't able to transform their lives in the same way. And even just from a psychological standpoint, when a judge is deciding someone's sentence, that judge is more likely to give additional incarceration time to someone who has remained in custody, because that person is showing up in front of the judge in shackles sometimes, in a jail jumpsuit. And it's a much harder leap for a judge to take someone who has been out of custody and who's been doing productive things, and then in the end, put that person in jail or send that person to prison. Also, when someone is incarcerated, and especially if their case has taken a long time, they start to lose hope. They start to adjust to their surroundings, really as kind of like a form of self-preservation. They start to see incarceration as their future, and they stop wanting to fight. I see that time and time again. Jocelyn mentioned how jails, detention centers can be very dangerous places. So the longer someone's in, the more likely they are to get into physical altercations, verbal altercations with staff that can also have negative effects on that person's case. And then finally, something that is also very, very severe is the immigration consequences that are tied to detention. And lots of people don't even recognize or understand this until they go through it with a family member or loved one. But if someone is a non-citizen and based on their immigration status or what they're being charged with, there could be an immigration hold that is placed upon them as soon as they are detained, meaning that no matter what, no matter if the next day their family shows up with the money to pay their bail, they will not be released. They will stay in custody through their entire criminal case. And then once it's finished, they will go to ICE to start fighting their immigration case. And for everyone, and especially people in that situation, their life and the lives of their family and the broader community would be dramatically changed by their ability to fight their criminal cases from the outside.
Summer, thank you so much for that really important overview. And Jocelyn, if you could just talk with us about, what the legal and policy challenges are to cash bail and to counteracting all of what Summer and Brittany has talked about.
Sure. Yeah, so one way to think about the challenges is also to think about what are the different kinds of laws and decisions that go into somebody being incarcerated pre-trial because they can't pay. There are initial decisions by police officers to make arrests. But if we move beyond that, bail is enabled by a number of different legal mechanisms. One is laws, statutes. So most states have a statute that explains the procedure for bail being set and the criteria, how and when bail can be set. There are also different rules within courthouses and courtrooms about procedures. And then bail is both enabled and constrained by bigger rules like constitutional rules, both state constitutions and federal constitutions. But the reason bail happens is not just because of these laws and rules, but also because of decisions that powerful people make. So the two biggest decisions are the decisions of a district attorney, whether it's an assistant district attorney on a case or a larger office, to request that bail be set in a particular case, because they do not have to ask for it. And then the second is the decision of the judge to impose bail, sometimes because the district attorney has asked for it, sometimes because of their own reasoning, and sometimes because some kind of assessment tool has recommended to them that they do it. So those assessments and tools are also part of the decisions. So legal and policy challenges are happening to every single one of those things. I want to talk about the federal constitution for a minute, because that's where some of the legal challenges in court have been happening. But I also want to emphasize and remember that the federal constitution is not the only way to change things. So, for people who have read the Bill of Rights recently, bail does come up. In the 8th Amendment, it says that there shouldn't be excessive bail. It turns out that that is sort of helpful, but not that useful of a mechanism, according to how the Supreme Court has interpreted the excessive bail clause, although it can sometimes be a way of making some inroads. But there has been federal litigation that has used other parts of the Constitution to make new, strong, and often winning arguments that some ways of setting money bail are unconstitutional. Although I do want to qualify by saying that no judge has ever said that money bail itself is unconstitutional. But under the Due Process Clause of the federal Constitution, some courts have started to question, because of work that groups and lawyers are doing, have started to question the processes through which people end up incarcerated because they can't pay. And then the Equal Protection Clause of the Constitution in the 14th Amendment has really only recently been interpreted by courts. And again, not because they thought of it themselves, but because groups have been organizing and pushing to think about it in new ways, to stop and say, wait a minute, if you take two people who are in the same situation, charged with the same crime, and one of them has money and one of them doesn't have money, and one of them ends up incarcerated pre-trial with all these devastating effects and the other one doesn't, that doesn't seem equal. That doesn't seem like equal protection. And so even very conservative judges, for example, on the Fifth Circuit Court of Appeals, one of the most conservative judges in all of the federal judiciary made that point and said, wait a minute, that does violate the Equal Protection Clause. So that's some constitutional work that's been going on. And because of that constitutional work, there have been federal lawsuits that have resulted in settlements or changes in rules. Sometimes those changes in rules require certain processes. For instance, might sound like a novel thing, but to have a hearing in front of a judge in which both sides are allowed to make arguments. That's sort of a process argument for changing money bail. Another thing that some settlements have required is courts to take into account somebody's poverty in deciding whether to set money bail. Sort of different settlements have come up with different ways to try to abide by the Constitution. But I do want to emphasize that although there's been some successful litigation and some settlements, and we can talk about settlements if people are interested, they can get very complicated. You can't just snap your fingers and a system is better. But there have also been policy and legal challenges in other ways. So think about these other levels of decision makers. There have been activists who have pushed and asked for district attorneys or voted for district attorneys who have made promises to ask for bail less frequently. There have been court systems or chief judges that have had new rules that either require to take into account whether someone has paid, or in Chicago, say you can't set money above what a person can pay. There have been constitutional amendments. New Jersey is an example, either outlawing money bail or making new requirements for how it should go. And then a lot of states are reforming their bail statutes. That's the legal mechanism that initially allows courts to set bail. There are a lot of states who have done or are doing this. Some in the past year or two include New York, California, and Colorado. And these statutes look wildly different, which give different, start to beg the question of what to do if we want to reform or fix money bail. If we get rid of money bail, there's not yet been a court system that's been willing to say nobody should be in jail pre-trial, although that is a position that a lot of groups who are pushing for change are taking and are fighting for. And so if we're going to detain some people pre-trial, a lot of important questions come up about who that's going to be. And so some reforms have happened. And when you look at who's in jail pre-trial, so Maryland was an example of this, it turned out that there weren't that many fewer people incarcerated pre-trial, and racial disparities persisted. And then there are some reforms that actually have resulted in decarceration. And so advocates are struggling and disagreeing over what should come after money bail. There's a lot of disagreement and debate over whether we should be using risk assessments or algorithms to try to give judges a better idea of how much risk somebody poses before setting bail. And so if you ask which jurisdictions are leading and which are falling behind, you're going to get a host of different answers. But before sort of we move on, I just want to, there have been a lot of legal and policy changes. And I'm a law professor, so it's not that I don't like lawyers, but I do want to sort of recognize that none of these changes would have happened if there weren't groups of people who have been incarcerated or who come from communities and families and neighborhoods that have been so devastated by the carceral state and have stood up and explained to us and shown the world what is happening with money bail, whether they've done it through bailouts that say, we're gonna bail out all Black mamas because we feel safer when Black women are not in jail than when they're in jail, no matter what they're accused of doing. They're people who are every day through the activist work that they're doing, showing us that these leading ideas in legal cases of public safety or of what a community is don't hold up when you look at how people live their lives. So I'm looking forward to talking about change, but I also want to remember that change isn't just when the most conservative judge writes an opinion saying, wait a minute, we're incarcerating people from their poverty. Change is also sort of people on the ground living out this idea that maybe people are safer when people are home with their families than when they're incarcerated pre-trial. So I'll stop there, but I think if there are questions about any of that, we could discuss more.
Brittany, you want to say something?
Yes, if I may. I think that was really awesome. And what I would add to that is also, as someone who has been incarcerated in the system, the part that I always invite people to think about is is to accept how we as a society have created climates that leave people vulnerable to incarceration in the first place. I think when we approach the conversation about cash bail, we must also take account of how we have failed children as a society. And then these children grow up to be adults who commit actions that we are no longer tolerant of, because we're not tolerant as a society of grown people who have not figured out how to live in society peacefully. However, we must also own the fact that we did not resource children in the sense that we have failed them in our institutions. So they grow up being educated through failing school systems. They remain living in houses that they rightfully should have been taken out of because they've been poorly cared for. They have eaten food that is banned in most countries that are civilized across the world, and how all of these conditionings of their social determinants while they were growing up factored to create a gumbo, if you will, or a recipe for disaster. So essentially, as a society, we have failed people in many different ways. And then we ask them to be successful adults without creating the proper setup for them to be successful. And that leads to a system of mass incarceration in the sense that we have locked away people we have not figured out a way to help. And we have decided that most of the mental health services that we will offer people will be through the county jail. The county jail in Dallas is the largest mental health provider in the county.
Brittany, thank you so much. And yeah, that's incredibly important. And to that end, next month, because it is Youth Justice Action Month, we will be having 2 additional panels touching on various issues within juvenile justice. And so thank you for bringing that up. And then kind of jumping off something that Jocelyn mentioned about alternatives to cash bail and risk assessment tools. So one of the questions we have from one of our volunteers, and anyone can jump in on this, whether risk assessment tools are better, and if they are, who should be conducting them? Yes, Brittany.
So I'll just open up the conversation. There's way more brilliant people on this phone who can speak to risk assessments in detail. I think you have to define better, right? Because unfortunately, when you're talking about solutions, there are not blanket magical solutions that offer perfect scenarios. It's going to take a number of different strategies. It's going to take a number of different creative approaches to right what has become a very large problem in America around mass incarceration. All of that context to say risk assessments are an imperfect tool. Because there is an algorithm to it and a calculation, there is room for it to be discriminatory, particularly to people of color. I want to hone in more and say particularly Latinx and Black people and Black women and Black men. And so with that said, we want people to have a risk assessment, but you also have to train the people who are using the risk assessment to evaluate people on the tool. So it's not enough to just put the tool into place, but you also must train pretrial services and judges and district attorneys to make sure that they understand what the pitfalls of the tool are and that they're using them accordingly.
Summer, go ahead.
Thank you. And going off of that, and just even harkening back to what Brittany was talking about in terms of the fabric of our society. If we just start, shifting our attention from, okay, we'll take cash out of it and we'll just use risk assessment. All of the biases, all of the racism, all of the systemic discrimination that our country was built upon is embedded in those risk assessments. It's embedded in the people who are performing them. So we can't just jump from, one negative lily pad to another one just because it looks shinier or it looks easier. It's not going to be objective. We have to figure out a way to approach this issue from a whole new direction. and not just really kind of distill it down to research, because all of that is based on a system that was created to disempower certain people. So obviously when you're using risk assessments, then certain people, people of color, people from Latinx and Black backgrounds are always going to come up as the riskiest, as the people that society shouldn't take a chance on, that society can't take a chance on, because then that'll be our downfall. So I think we have to reimagine how we are approaching this issue to come up with a better solution that just doesn't take us back to the exact same position that we're in now.
Jocelyn or Adam, do you want to weigh in?
Everything they said.
Perfect. Okay, so then moving forward, one of the things that we talk about a lot at the Justice Collaborative, and I think all advocates do, is how we talk about certain criminal justice issues and the role that narrative plays in reform. And that comes up a lot in the media, and a lot of how we think of crimes and who's a criminal and how severe things are is constructed by what journalists are telling us. And so, Adam, if you could touch on, how the media is covering bail and how it could be doing a better job of that, that'd be great.
Hi. So yeah, I primarily deal with, I guess, the sort of backlash to the reform, which is to say that now that we're, more or less 2 years into some type of reform in places like Chicago or Suffolk County or Philadelphia, that you're starting to see emerge this kind of reactionary media narrative that is both predictable and I think going to get much worse. And obviously for the public to sustain criminal justice reform in general, but specifically cash bail reform, you have to be able to sort of address that backlash. Specifically because most of our cultural products, news media, pop culture are systemically embedded with the police. Local news is reliant on police. Our pop culture products, Law and Order, so forth, are overwhelmingly pro-police. And you're starting to see this sort of play out already. And so I wrote an article that was basically going to summarize the kind of 5 major tactics, which I'll do a really quick overview if you'll grant me that, which is the kind of overarching fear of all this is what people generally call the kind of Willie Horton effect, which is where anytime you let anyone out of prison ever, if that person goes on and commits any kind of crime or is alleged to commit any kind of crime, that is going to be used against the prosecutor, the mayor, the county commissioner, everybody. And this kind of fear of the Willie Horton is the thing that has largely animated the kind of lock them up and ask questions approach later. Now, the Willie Horton thing itself was, for those who don't know, was there was an African-American man who was released on a furlough program in Massachusetts. He went to Maryland, committed a rape. And this was used against Dukakis in the '88 election by George H.W. Bush, and became a kind of mythology about how we shape reform in prison. And you're seeing this more and more in places like, so for example, the Boston Globe did a piece about how Suffolk County was letting too many people out of jail, and it was worrying experts. And who are their experts? It's a laundry list of prosecutors and cops. You see this a lot with local news in Chicago. They'll typically focus on emotionally charged cases. There was a teacher, a white teacher in downtown Chicago who was robbed, and the guy who robbed him allegedly robbed her was and anytime there's a kind of a racial element to black on white crime or whatever, they'll freak out even more. Who robbed him was let out on a $100 bill, or a $100 bond. So John Cass, who's a local columnist for the Chicago Tribune, wrote 2 different articles on it and talked about how her life was only worth $100. And this is the thing that keeps politicians up late at night, because it plays well in local media, AM radio, right-wing columnists. You're seeing this even creep into Fox News more and more. And this is a tactic we're going to see, I think, time and again, where cops will basically find the most racially charged and most emotionally charged cases, leak them to local media, and they'll sort of jump on it as this Willie Horton sort of fear-mongering case. Now, of course, the most elegant solution to preventing that from happening would be to lock up 100% of the population. That way, we never have to worry about it. But then you get into kind of the other side of the equation, which I'll get into in a second, which is the violence of prison itself. The second thing you see often is racist imagery. There was a Chicago 2 story about how there was 9 shootings in Chicago over the weekend, and how the police were blaming it on bail reform and letting people out on gun charges. Now, there was actually zero connection between the shootings. Like, no one who had committed any of these shootings was out on bail, which you see time and time again. In fact, the numbers are 1 to 3%, depending who you ask, in terms of reoffense. Violent offense is less than 1%. But they juxtaposed this story with the African-American man's mugshot who was out on gun charges and had committed domestic violence from 3 years prior. So actually before there was reforms, but it didn't matter. All they really needed to kind of gin up the gentrifying and suburban white, the sort of scared white people they were targeting was an image of an African-American mugshot. So you'll sort of see this happen a lot. Another a sort of trope you see is the idea is honing in on liberal wedge issues. And this one gets a little dicey, but there's basically, if you'll notice, many of the fear mongering over bail reform is domestic violence. The Chicago Tribune did a large spread about people out on cash bail who later went back and committed domestic violence. Now, liberals and reformers need good answers to that, but that's a way of sort of taking people who would otherwise be sympathetic and trying to peel them off, turning them into sort of what people call carceral feminists. The second thing is guns. Guns are obviously very popular. Gun control is very popular with liberals, but increasingly you'll see the backlash against bail reform focuses on habitual gun offenders and equating gun offenses with gun violence, and that everyone thinks they've sort of cracked the Da Vinci Code because they're, I'm one of the good liberals, but let's just put everyone who's arrested for guns in jail. Well, you're not going to really do anything about mass incarceration if that's your attitude. And these are part of, I believe, deliberate strategies to peel off people who are otherwise sympathetic. And the fifth, and I think most important part of counter narratives to sort of counter the backlash against reform is the idea of this, and you guys have already talked about this, so I won't go on it too much, is establishing the violence of jail. Establishing the sort of moral stakes of jail and prison. And that it's not, in that all you hear about is, the victim and the victim's violence, but no one ever talks about ever. In any of these reports, in any of the Chicago Tribune, the Chicago CBS 2, the Boston Globe piece, no one talks about the violence of prison on the other side of the equation. And one thing I think that reformers have to do is really work hard to kind of establish that. And I actually think the Netflix series, When They See Us, did a really good job of doing this. In fact, this is the only kind of cultural product I've seen that really lingered on the suffering of prison for longer than 5 minutes. You had a whole kind of hour and you kept thinking, okay, well, when are we going to cut away from this and go to this next? No, it's just hour and a half. And I think creating pop culture narratives, and maybe that's perhaps a little off topic, but I think it's important to give people in a pop culture sense, the kind of context of what's really at stake here, that it's not just putting people in a cage and you never hear from them again, but these are real humans and there's real suffering. So when you say, oh, we're going to add, our brilliant solution to gun violence is we're going to add 5 years onto gun possession charges, that means something, that has moral stakes, that has moral property, and that's going to result in real suffering. So we're not so blasé when we come to putting people in jail, because the one thing this country's good at is our solution to everything, no matter what it is just put people in jail. And that's the first thing we want to do. And that there's stakes when you do that it isn't an abstraction. These aren't just years. These are real human beings. And I think testimonials from people who've been in jail and pop culture products, like When They See Us, things like that are important to really do that, because you need a kind of ideological kind of thingamajig to really attach yourself onto. And so I think as we're having this conversation, thinking about how on a day-to-day basis, the sort of talking points you use to counter this Willie Horton dynamic is, I think, going to be very important, because as reform takes place and more people are let out of jail pre-trial, you're going to see there's going to be more and more sensationalist cases that people try to latch onto to demagogue the issue and to kind of fearmonger the issue, to go back to the good old days, which of course weren't even that long ago, and we still live in the bad days, but relatively speaking. So that's my 2 cents.
Adam, thank you so much. And I mean, I would love if you would bring us into our next topic of conversation, which is what is being done now. And so Adam, if you could talk about the role you're playing in changing the narrative and challenging, false.
Well, it's not very romantic, but I think getting into one of the things we talked about is, I know that the Justice Collaborative has its own kind of media, and they try to get op-eds in the LA Times, and that stuff's really important. But I really think what's also very important, and it's a little thuggish, but I think going after bad journalism and calling out people who are trafficking in these racist narratives and sort of naming names is really important. And everyone can do it. It's the power of social media. Everyone has an inner media critic in them. But I suggest that if you see something that's bad or is playing to Willie Horton narratives or demagoguing or misinforming, that you go after, because again, a lot of these reporters at these local media outlets, they're not sinister. They're just part of a kind of machine, although some of them are. But they're part of just a mindless machine of tough on crime. 90% of their stories are given to them by police, painted by police, or informed by police. And police are seen as these kind of neutral government officials, as one would see sort of a dog catcher, or, they're kind of these morally neutral figures who are just worrying about solving crime. And they don't think critically about the huge conflicts of interest. Long pretrial detention is a huge leverage to extract confessions out of people. Long pretrial detention is a huge leverage to flip people as informants and snitches. They have every incentive to keep people in jail pre-trial, and yet the media approaches them as these kind of neutral government officials. And I really think steering people away from that and going after the low-hanging fruit, specifically in local news, is one way you can do that. Because I do think that creates the environment that makes reform, and will, I think, more so in the future, make reform that much more difficult.
Absolutely. Brittany, did you want to say something?
I think Adam brings up a really important point that I want to hone in on, as far as pretrial incarceration being an incentive. And when I say incentive in the form of, it does motivate people to go ahead and unclog the system in the form of what we call copping to pleas. That even in fact, if they're not guilty of the crime they're being accused of, just because of the sense of hopelessness that Summer referenced earlier, they're more motivated just to accept a plea in hopes of being on probation and then being physically free to enter back into society to reassume their life. And what happens is that probation in those types of instances become the entry point into the system of mass incarceration. Because when you talk about probation, if you are violated, it leaves you vulnerable to re-enter right back into the system and start on a pathway of which has often become decades of being entangled in the criminal justice system. Also, very quickly, the point of being an informant, or in the streets, we call it a snitch. Please do not take that lightly, because that literally becomes a dangerous atmosphere for people are no longer safe to live in their community. Their families are not safe to live into their community, because one of the most terrible things that you can be in your community is a person who folks do not feel like they can trust. And that is a very difficult concept to navigate your way out of. And I cannot emphasize that even the accusations of being a snitch are very dangerous, particularly in communities of color, where we rely on each other to be safe.
Thank you, Brittany. And while we're on you, if you could just talk about the amazing work that you're doing in Dallas.
Yes, I'm very fortunate to do what we call faith-based organizing. So I spend many of my days talking to members of the faith community here in Dallas County and imagining different ways to come against the demon of mass incarceration, if you will. So particularly what that looks like is we have an opportunity where we are in our own federal fight against money bail here in Dallas. Back in 2018, at the beginning of the year, several lawyer organizations came together and they sued Dallas County for unethical bail practices. What we found is that a lot of these bail hearings were happening under 90 seconds. So within 90 seconds, a magistrate judge was deciding the fate of your life. And what we found about that is that many people were also not aware of why they were being given these particular bonds. So it was almost like a menu. If you committed this crime, you were automatically given this bail without much consideration for your particular self-interest if you have the ability to pay. And so after this lawsuit has dropped, what is very different about this lawsuit in the original Harris County, that Houston, Texas lawsuit, is that the felony judges in particular were individually named on that lawsuit. And we have found them to be our biggest dissenters against making measures of improvement against money bail. They are represented here in Texas by the Attorney General's office since they're state employees. And that Attorney General, Ken Paxton's office, has not operated in transparency with us understanding what the judges' concerns are in making these improvements to money bail. We recently elected a new district attorney, John Creuzot, who has come out as our first elected public champion of money bail. And he has offered a number of reforms that should be made to the current existing system to improve poor people's chances of not being incarcerated, just particularly for being poor. So after many months of attempting to talk and meet with people and being rejected and disappointed, my team and I have decided that it is time to lift up a public message around money bail here in Dallas County. We understand people are really busy, and even though we are nerds who think about this concept every day, that is not true for all of the public. So what we plan on doing on October 15th is coming out with what we're calling the Day of Demand. One thing that makes money bail very particularly difficult to understand here in Dallas County is so many different people have an interest or have responsibility in solving it. So it's not like you're just going after one person asking them to do one thing that would turn everything upright. You need the county commissioners to approve the funding necessary for everybody to have the budget to implement the changes that need to be made. We need the public defender's office as well as the district attorney's office to be on the same page so people can get adequate representation and can be processed and prosecuted in a fair, understandable way. We need the sheriff to give us accessibility to these hearings. So our narrative around this whole movement is kind of, what are you hiding, Dallas County? We can't physically see the hearings here in Dallas County because they happen in a portion of the jail that the public doesn't have access to. And what we know, and what Jocelyn could probably speak to, is that we understand that when people go before a decision maker and they have family and public support, that they are more able or likely to get leniency in order to be released. Also, we believe that people should not be held captive or pre-trial unless there are extenuating circumstances that prove that they are a threat to themselves or society. By default, people should not be incarcerated. We should honor the presumption of innocence that is demonstrated and entitled to us through the Constitution, and we should be more likely to release people than to detain them because of all of the earlier listed reasons of the effects we know incarceration has to people's lives. So with that, we're asking this to be a national moment where the whole country shines the light on Dallas County and takes a look at Dallas County, understanding that this federal lawsuit has the opportunity to set precedent, not just in North Texas, but across the country, of what the effects of bail has on people's lives and what the standard of how people should be free, particularly Black and Latinx people, and particularly poor people who are most vulnerable to fall into the system. With that being said, the name of our movement is Dignity Over Dollars, a coalition to end money bail. And we have a website, dignityOverDollars.org, that is currently being updated. And we invite all of you to log in, stay plugged into Faith in Texas, ACLU, the RFK Foundation, all of our coalition, so that you can stand with us and ask these decision makers, particularly the felony judges, but even more specific, Tammy Kemp, the presiding judge, the face of the felony judges. And you all know Tammy Kemp because she is the current judge sitting over the Amber Geiger trial, the officer who has been accused of killing the Black immigrant Botham Jean here in Dallas County, September 6th last year. She is also the presiding judge, meaning the decision maker of the judges, who we are asking, what is their dissent to bail reform? What are you hiding? Why aren't you transparent about what is taking place as far as poor people being kept in prison, kept incarcerated just for being poor? So I would love to send you all more information about this movement and invite you to stand with us, make calls, share on your social media that this is happening, send emails, and just please help to magnify this opportunity to set precedent on what bail reform should look like, starting here in Dallas County.
Brittany, thank you so much. That was amazing. And I am excited for how we can have our justice volunteers partner with you all. And so I look forward to working together on that. Summer, can you talk about the role that TJC is playing in combating cash bail?
Yes. So TJC is working to support and amplify the work of groups and community activists across the country who are working to push against cash bail and who are pushing for pretrial detention reform. And I will highlight just a few of the projects that we're working on. So a few of the jurisdictions that we're working in. So we're working in Cuyahoga County in Ohio. So that's in northern Ohio. That is the county that includes Cleveland. And recently that county has been in the news because during a 9-month period between 2018 and 2019, there were 9 people who died in that Cuyahoga jail. And the jail was highlighted as being one of the most inhumane jails in the country. After this, a group of community leaders, community organizers came together to create a coalition. The coalition issued a letter to the DA in that county, DA O'Malley, asking him to develop a more comprehensive jail policy, one that bases detention decisions on safety rather than on wealth. And the coalition is organizing an upcoming event. Is actually on October 8th. So anyone who is in Cuyahoga County can participate. It is a criminal justice march for action. It's an opportunity for activists and community members to come together, to meet, to join their voices, and to march to demand that DA O'Malley stop sending people to jail just because they can't afford to pay their bail, and also that he stops sending people to jail who are suffering from addiction or mental illness. As Brittany highlighted, and as many of us know, that jails in our counties are usually either our county or our state's biggest mental health provider. I'm in Los Angeles, and that is the position that we are in. We run in LA the biggest mental health hospital basically in the country, and that is the county jail system. And so they're pushing for that. And finally, they're pushing the DA to no longer incarcerate children. And there is a Facebook group and a way to get more information, so I can send that to Kelly for all interested volunteers who would like to come out on October 8th. We're also working in Harris County, which is in Texas. There, TJC is supporting and amplifying the work of activists who are pushing for Harris County bail system reform. In 2018, a federal court found that the Harris County's bail system was unconstitutionally discriminatory against poor people. And I think that, that can be said about many bail systems across this country. And in response, the county actors, including the sheriff's department, the DA's office, came together and they were tasked with implementing a bail reform settlement. And first, everyone was on board, but then at the very end, Harris County DA Kim Ogg started to object to the proposed reform. She started using fear-mongering tactics to say that these bail reforms should not be put into place. And she actually distanced herself from the sheriff's department that was on board with these reforms. And she more so kind of aligned herself through argument with the arguments of the bail bonds industry. And in the end, the federal judge basically objected to her objections and implemented the settlement. So they're happy about that, and we're continuing to work with groups to see hopefully those reforms go into practice. Next, in Fulton County, Georgia, TJC is working to support community groups that are challenging DA Paul Howard's tough on crime approach to bail. If anyone knows, DA Paul Howard has been in office since the 90s. And so it takes a lot to move him. It takes a lot to motivate people to try to get him to change his positions because they feel like he is just an institution. And so what we're doing there is highlighting the untold stories of people whose lives have been devastated by unnecessary pretrial detention, and really shining a light on some of the different effects that we've talked about during this webinar today. And then lastly, in LA County, in California, where I am, TJC is continuing to support the work of local community groups that are advocating for alternatives to incarceration that need to begin at the time or even before an arrest, and not just at the time of sentencing. So we're thinking of ways to help people instead of just ways to detain people. Additionally, we're working to support and amplify the work of groups that are advocating for thoughtful and long-term pretrial reform. This kind of harkens back to our discussion of what comes next after cash bail. So we don't want to replace one bad system with another, but instead trying to develop a novel reimagining of the pretrial landscape that values care, safety, and equality over detention. So those are just a few things that we're working on.
Thank you, Summer. And Jocelyn, can you wrap us up with talking about the work that you're doing and the role of folks on the ground?
Sure. Yeah, I'm less interested in talking about the work that I'm doing as a law professor, although I'm always happy to talk to people, and more in just lifting up. What I try to do is support and work with people who are engaging in efforts on the ground that are just like the ones that we just heard about. And I guess instead of describing particular things, because I think we just heard amazing examples of particular groups, I would just encourage people out there. One way to get involved is to come to the people on this call and experts and learn who's doing the work. And another way is to look at your own community and your own courthouse and try to figure out who is doing work here and who can I join with. But I guess I just want to emphasize the communal and collective nature of the most exciting things that are happening. When you think about the word community, it's actually a word that's been weaponized to justify pretrial detention and to justify money bail. So people are incarcerated pretrial to protect the community. And judges look to whether people have community ties. We heard reference to this, people in the courtroom. And when people make collective efforts to stand up and to articulate and live through their practice of supporting each other outside of incarceration, they show a different idea and they live a different idea of what community is. And so what I think is exciting about this phone call is that we're connecting narrative to legal change and to real change. That stuff is real, but you can also live out collectivity and live out community. And when I think of an ideal world that perhaps doesn't even have pretrial detention, part of the way we get there or get to large-scale decarceration is by redefining community in collective ways and through making connections, including across racial and class boundaries. Just remembering that no matter who you are, there's a way to find a collective and work, especially with people who have been incarcerated or whose loved ones are, to show that public safety, that's another term, can mean people being free, does mean people being free, and community can mean taking care of each other in ways that don't involve jail. That's all.
Jocelyn, thank you so much. And thank you to Summer, Adam, and Brittany for weighing in on this really important discussion. And so right now we're gonna shift over to Molly, who's kind of gonna follow up on what Jocelyn was saying about how people can be engaged in this day-to-day fight.
Yeah, thanks so much, Kelly. And thank you so much to you, Brittany, Adam, Jocelyn, and Summer. We're so excited to have you share some of your expertise with us and to learn from, everything that you've done so far. I think all of you laid out really well and clearly the ways in which getting involved in this in lots of different ways, not only sort of the movement and to end money bail and work towards reform in that area, but in other criminal justice issues more broadly, is so important. And I think one of the first steps is, taking time out of what we know are really busy schedules and lives to learn about these issues. So I just want to thank everyone who's joined us live and to those that will be watching later. Thank you for taking the time to learn about this. And I think it's a really important first step, and we hope that you'll take a lot of the incredible information you've gathered from this webinar and share it with people in your communities, those that maybe are already paying a lot of very close attention to these issues, and those that aren't at all. So I just very quickly want to talk about a few things that we do in Justice Volunteers that I think maps on very closely to everything our panelists have said today, and talk about ways that we hope that you'll join us in getting involved in criminal justice reform more broadly, and then this issue in particular. So we have sort of three main teams, although many people are involved in a few or all of them. The first one involves research, which is volunteers that are taking time to help break down a lot of the lack of transparency that surrounds a lot of these issues. So we have large scale and smaller scale research projects that we invite volunteers into. Some of these are national in scope, some of these are more local and specific to where you're living, where you and your community are located. And then very closely related to that is our media amplification team. We heard a lot of really interesting insight from Adam today and our other panelists about the importance of narrative reform and shifting the narrative on these issues to help people understand things in a different way. But Jocelyn mentioned understanding community in a different way rather than the way that it's typically used in these conversations around bail and other criminal justice issues. And so we ask volunteers to share on their social media pages and in other ways with their communities, important articles, events, and things that are going on these issues. And then finally, our third team, which again sort of ties together research and media as well, is more focused on action. And I think it was very exciting to hear Jocelyn talk about the critical role that organizers and people on the ground have played in really moving these other levers of change on this issue, whether it's pressuring DAs or prosecutors to take a different role, pressuring legislators to enact different legislation that helps move reform forward. We work with partners on the ground, many like you're doing the incredible work that Brittany's doing in Dallas to try and connect people with opportunities where they live to really make a difference in person, in addition to doing stuff remotely. So we have a poll really quickly, just like to take 1 minute or less than that. We should have those pop up that asks if you'd like to join any of those teams, if you're interested in helping us work on cash bail projects specifically. And if you could just take a moment to click those, that would be great. And I'll turn it back over to you, Kelly, to hopefully get to a question or two before we wrap up.
Thanks, Molly. And yes, so we're running a little short on time, but I think it's important to continue the conversation about, what life after cash bail looks like. And so one of the questions that we got from a volunteer is, whether or not we can talk about the increase in electronic surveillance when we talk about moving away from cash bail. And so if any of our panelists or all of them can weigh in on that, it'd be great.
I can start it off. Like I said, I worked as a public defender, and oftentimes, in order to get my client out of custody, we would say, hey, he or she is fine with electronic monitoring. So usually electronic monitoring is like an ankle bracelet that the person has to charge, and they have to wear it all the time. And yes, it's an alternative to incarceration, but it's something that we are seeing is being abused. And it's not, just an easy thing like, okay, well, now I'm not going to be in jail, so I'll just wear this ankle monitor and it's going to be really easy. Depending upon where the person is, they have to pay for it. They have to pay for it each and every day. Many people who are going through the criminal legal system do not have a lot of money, so it's a huge financial burden to pay for this ankle monitor every day. They have to make sure that they charge their monitor. Sometimes they could get monitors that are defective. Sometimes they're living in places where the electricity isn't reliable, where they don't have outlets. And I think that we think like, oh, this is something that's easy, but it's really burdensome. Or if they have to go far for their work, if they have to take public transportation, if they are just walking around and they are not able to stop and charge their electronic monitor, then that would alert maybe a pretrial detention officer or a pretrial officer to say that that person is not compliant. And then they're back in front of a judge who is upset, thinking like, oh, I gave this person a chance and they're squandering it. Not because of any ill will or desire on the person's part not to be compliant, but because of a faulty system or these really the issues that are inherent in just having a shackle. And really just what that says to society when people see that you're a troublemaker, that there's something wrong with you. And so it affects the person socially. I've had to talk to clients about what to do when they take a shower, because it can be on them all the time. I was talking to someone else that works at the Justice Collaborative, and in jurisdictions across the country that are relying on these electronic monitoring devices, sometimes they aren't even allowing people out of jail because there is a shortage. And so people are staying in jail waiting for these things to become available. So it's just actually perpetuating the system of pretrial detention, because instead of being a way out or an avenue for someone to go home, it just further complicates that prospect, and it could just further delay it.
Yeah, what I would contribute to this conversation, once again, putting the burden and the responsibility back on society, is that there is a lot of profiteering that happens in the mass incarceration space. Just about anything that pertains to incarceration, and that goes from the commissary that people eat, the telephone calls that they make, the monitoring, all are attached to somebody's profit. So we have to begin to have a conversation about how capitalism is hindering the improvements we're trying to make to mass incarceration. Because some of the solutions that could be met to reduce some of these costs and reduce some of these problems will directly correlate to the reduction in profits in some of these major companies, so that they lobby to keep these policies in place because of how they profit off of them. So as a society, what that means for us is we have to make a decision about which one is more important: capitalism and money, or the dignity and quality of people's lives. We have made a decision at this point, and that is to profit and to be capitalists. Now we have to move forward and see that the collateral of that has been this system and institution of mass incarceration, and how we have literally profited off of Black and brown bodies in particular. And this leads to a larger conversation around prison labor, the cost of phone calls that we're all very uncomfortable with, but we must begin to wrestle with if we're going to talk about pre-trial incarceration. It's directly tied to profiteering and capitalism.
Thank you so much. And thank you again to Jocelyn, Summer, Adam, and Brittany. This was a great conversation, and it's definitely only the start, because we do want to keep you all connected to our justice volunteers. Adam and Jocelyn, did you all want to say anything? Perfect. Okay, so before we all go, I would love to get your feedback. And so there should be a poll up now asking how you would rate the webinar and how likely you are to join for future webinars. And like I mentioned in response to Brittany's amazing comments about juvenile justice, next month is Youth Justice Action Month. And because of that, we'll be having two webinars, one focusing on the role of homelessness and juvenile justice, and then another one focused on the criminalization of adolescent behavior in communities of color. And so you will be getting information about that as we follow up to this webinar. So thank you again to our amazing panelists, and thank you all for tuning in. Enjoy the rest of your day.